The Colonial Bar of Virginia and Maryland, page 39, chapter 2. The history of lawyers in Virginia is a peculiar one, for in no colony was the early prejudice against the profession stronger, and in none did a more eminent bar develop. The binding force of the common law was early recognized, and in the preamble to the revision of the statute laws made in 1660 to 1661, it was stated, "We have endeavored, in all things, as near as the capacity and constitution of this country would admit, to adhere to these excellent and often refined laws of England, to which we profess and acknowledge all our obedience and reverence." Hugh Jones, in his Present State of Virginia, wrote, in 1724, that Virginia was ruled by laws, customs, and constitution of Great Britain, which it strictly observes, only where the circumstance and occasion of the country, by an absolute necessity, requires some small alteration, which nevertheless must not be contrary, though different from and subservient to the laws of England. And Judge Story, in his Commentaries on the Constitution, remarks that the laws of Virginia, during its colonial state, do not exhibit as many marked deviations in the general structure of its institutions and civil polity from those of the parent country as those in the northern colonies. The common law was recognized as the general basis of its jurisprudence and expressly provided for in all the charters, and was, in its leading features, very acceptable to the colonists. In the earliest days of the colony, the governor was the sole fountain of justice, and in the instructions laid down for Sir Thomas Gates, governor in 1609, under the proprietary charter of 1606, it was enjoined that, in all matters of civil justice you shall find it properest and usefulest for your government to proceed rather as a chancellor than as a judge, rather upon the natural right and equity than upon the niceness and letter of the law, which perplexeth in this tender body rather than dispatcheth all causes, so that a summary and arbitrary way of justice, discreetly mingled with those gravities and forms of magistracy as shall in your discretion seem aptest for you and that place, will be of most use for both expedition and example. In the same year, a civil code was prepared entitled Laws and Orders, Divine Politic and Martial for the colony of Virginia. In 1618, provision was made for two judicial bodies, the Governor and Council and the Assembly. This latter body, composed of 22 elected burgesses, and the Governor and Council convened at Jamestown, July 30th, 1619. The first English legislative body in America, and on the second day of its sitting constituted itself a court to try one Thomas Garrett for indecent behavior, and later in the session it heard a civil case. In 1643 a judicial system was established much resembling that of Massachusetts, consisting of county courts, begun in 1623-24, composed of local wealthy planters, with an appeal to the quarter courts, or general court, as they were termed after 1662, composed of the governor and his councillors, 13 in number at first, later 19, and still later 16. There was also an appeal in some matters to the General Assembly. As early as 1661 to 1662, an act was passed regulating very precisely the procedure of the courts and requiring all declarations, answers, and evidence to be preserved. Notwithstanding the early acceptance of the English common law as the basis for its own law, Virginia produced no trained bar for nearly 100 years. This condition was undoubtedly due to the fact that its governing class was practically a landed aristocracy, conservative and extremely jealous of any other power. The colony, however, seems to have been troubled from an early date with the lower class of petty attorneys, at the problem of how to control these attorneys appears to have perplexed Virginia more than any other colony. As early as 1642 to 43, under an act for the better regulating of attorneys, and that great fees exacted by them, fees were confined to 20 pounds of tobacco in the county court and 40 pounds in the quarter court. Attorneys were forbidden to plead without obtaining license from the court. They could not plead at more than the quarter court and county court, and they could not refuse to be entertained in any cause, under heavy fines to be paid in tobacco. This also, however, did not apply to such who shall be made special attorneys within the colony, or to such who shall have letters of procuration out of England. In 1645 it was provided that, whereas many troublesome suits are multiplied by the unskilfulness and covetousness of attorneys who have more intended their own profit and their inordinate lucre than the good and benefit of their clients, be it therefore enacted that all mercenary attorneys be wholly expelled from such office. In 1643 the courts, if they perceived that either party was like to lose his cause by his weakness, were themselves to open the cause, or to appoint some fit man out of the people to plead the cause, and not to allow any other attorney in private causes betwixt man and man in the country, and attorneys were forbidden to take any recompense either directly or indirectly. The Mercenary Attorney Act was repealed in 1656, and provision was made for licensing attorneys. The next year, however, trouble apparently having again risen, all fees were taken away from attorneys, and whereas there doth much charge and trouble arise by admittance of attorneys and lawyers through pleading of causes, thereby to maintain suits and laws to the great prejudice of charge of the inhabitants of this colony, they were forbidden to plead in any court or give counsel in any cause or controversy for any kind of reward or profit, on penalty of 5,000 pounds of tobacco, and were required to swear, when they appeared in any cause, that they had not violated this act, because the breakers thereof, through their subtility, cannot easily be discerned. In 1680, however, a law was passed again, allowing attorneys to practice under rigid restrictions and after license by governor. The following reason for this reversal of policy was given in the preamble to the statute: whereas all courts in the country are many times hindered and troubled in their judicial proceedings by the impertinent discourses of many busy and ignorant men, who will pretend to assist their friend in his business and to clear the matter more plainly to the court, although never desired nor requested thereunto by the person whom they pretended to assist, and many times to the destruction of his cause, and the great trouble and hindrance of the court. This act, being found inconvenient, was repealed after 2 years, but the repealing act was itself annulled by royal proclamation. As late as 1705, Beverley wrote in his History of present state of Virginia, "Every one that pleases may plead his own cause, or else his friends for him, there being no restraint in that case, nor any licensed practitioners in the law." In 1732, however, another statute was passed declaring that the number of unskilled attorneys practicing at the county courts is become a great grievance to the country in respect to their neglect and mismanagement of their clients' causes and other foul practices, and providing for licenses for the admission of lawyers upon the taking of an oath, the form of oath being practically that in use in the New England colonies. There appears to have been a distinction, however, at this time between that class of men who practiced only in the county courts and those who appeared in the general court. for this statute of 1732 provided that it should not be construed to extend to any attorney who at the time of passing thereof is a practitioner in the general court, or to any counsellor or barrister at law whatsoever. This reference to the distinction between attorneys and barristers is one of the earliest in all American colonial legislation or court rules. Finally, in 1748, a general statute provided for licensing of all lawyers and also a form of oath to be taken by them. All this early legislation was directed probably not so much against the legal profession itself as against the character of the men who composed it. Most of the attorneys were mere charlatans, men of no character or influence. As Judge Minor said in his Institutes, for fully a century the lawyer seems to fortune and to fame unknown, not one of them having attained a notoriety or distinction worthy of a biographer. John Fiske says that they were frequently recruited by white freed men whose career of rascality as attorneys in England had suddenly ended in penal service. Although this statement is unqualifiedly denied by a Virginia lawyer, claiming that there are no records to sustain it, there is record in 1736 of one Henry Justice, an English barrister of the Middle Temple, who was convicted of stealing a Bible and other books from Trinity College Library in Cambridge, and sentenced to transportation to Virginia. The fact undoubtedly is that the litigation in the courts was so simple and so exclusively confined to commercial matters, actions of debt, and on bonds, that it was largely entrusted to the prominent officials and wealthy merchants and planters. The business was not lucrative enough to attract educated English lawyers, and above all, the ruling class in Virginia were the landowners, who eyed with suspicion the rise of any other class to positions of influence in the community. Moreover, the courts themselves were composed almost exclusively of these landed gentry, who had no trained knowledge of law, and in practicing before whom such knowledge was of little avail. Thomas Jefferson well described the conditions of practice as late as the middle of the 18th century as follows. When I was at the bar of the General Court, there were in the possession of John Randolph, Attorney General, 3 volumes of MSS reports of cases determined in that court, the one taken by his father, Sir John Randolph, a second by Mr. Baradol, and a third by Hopkins. These were the most eminent of the counsel at the bar, and give us the measure of its talent at that day. I must have penciled some brackets around this next sentence. All, I believe, had studied law at the Temple in England, and had taken the degree of barrister there. The volumes comprehended decisions of the court from 1730 to 1740, as well as on cases of English law as on those peculiar to our own country. The former were of little value, because the judges of the court consisting of the king's privy councillors only, chosen from among the gentlemen of the country for their wealth and standing, without any regard to legal knowledge, their decisions could never be quoted, either as adding to or detracting from the weight of those of the English courts on the same points. Whereas on our peculiar laws, their judgments, whether formed on correct principles of law or not, were of conclusive authority. As precedents, they established conclusively the construction of our own enactments and gave them the shape and meaning under which our property has been ever since transmitted and is regulated and held to this day. In 1680, there were 33 lawyers in the colony, but with the exception of the Royal Attorney General and Benjamin Harrison and William Fitzhugh, who was born in 1651 and educated as a lawyer in England, no lawyers of any note appeared to have been in practice in the 17th century. In the early 18th century, most of the Virginia lawyers had received an Inns of Court education in England. Prominent among them were William Byrd of Westover, who, born in 1674, studied law in the Middle Temple, collected the finest library in the American colonies, and died in 1743. John Clayton, who was born in 1665, studied law in the Inner Temple, was made Attorney General of Virginia in 1714, and died in 1737. Edward Barradall, who was born in 1704, was Attorney General and Judge of Admiralty, who died in 1743. William Hopkins, a well-educated lawyer who practiced in Virginia for 12 years prior to 1734. Sir John Randolph, who was born in 1793, graduated the College of William and Mary, studied law at Gray's Inn and the Temple in London, and ranked at his death in 1737 as one of the great practitioners in America. Stevens Thompson, one of the early attorneys general, and John Ambler, who practiced between 1735 and 1776, both of whom had studied in the Middle Temple. The lawyer of largest general reputation prior to his death in 1734 was probably John Holloway, who had been an attorney of the Marshalsea Court in London. Though described by Sir John Randall as relying more on learning and the subtle artifices of an attorney than the solid reasoning of a lawyer, his opinions were looked upon as authoritative, and his fees were exorbitant. Between the years 1750 and 1775, there was a marked growth in the size and ability of the Virginia bar, and there arose a group of lawyers, most of whom were educated either at Princeton, William and Mary, or in the English universities, or Inns of Court, and whose political and legal talents placed Virginia in the forefront of the American colonies. Among these were Peyton Randolph, John Randolph, Edmund Pendleton, John Blair, John Lewis, George Wythe, Robert Carter, Nicholas, Thomas Jefferson, John Tyler, Dabney Carr, Peter Lyons, George Johnson, Paul Carrington, George Mason, Richard Henry Lee, and Patrick Henry. Some lengthy footnotes. The Virginia bar before the Revolution was thus interestingly summed up by St. George Tucker in a letter to William Wirt in 1813. Literary characters may leave their works behind them as memorials of what they were. Soldiers may obtain a niche in the temple of fame by some brilliant exploit. Orators, whose speeches have been preserved, will be remembered through that medium. Judges whose opinions have been reported may possibly be known to the future judges and members of the bar, but the world cares little about them, and if they leave no reports or meet with no reporter to record their opinions, etc., they sink into immediate oblivion. I very much doubt if a single speech of Richard H. Lee's can be produced at this day. Nevertheless, he who, the most mellifluous orator that ever I listened to. Who knows anything of Peyton Randolph, once the most popular man in Virginia, Speaker of the House of Burgesses, and President of Congress, from its first assembling to this day, or to the day of his death? Who remembers Thompson Mason, esteemed the first lawyer at the bar, or his brother, George Mason, of whom I heard Mr. Madison, the present president, say that he possessed the greatest talents for debate of any man he had ever seen or heard speak? What is known of Dabney Carr, but that he made the motion for appointing committees of correspondence in 1773? Virginia has produced few men of finer talents, as I have repeatedly heard. I might name a number of others, highly respected and influential men in their day. The delegates to the first Congress in 1774 were Peyton Randolph, Edmund Pendleton, Patrick Henry, George Washington, Richard H. Lee, Richard Bland, and Benjamin Harrison. Jefferson, Wythe, and Madison did not come in until afterwards. This alone may show what estimation the former were held in, yet how little is known of one half of them at this day. The truth is that Socrates himself would pass unnoticed and forgotten in Virginia if he were not a public character and some of his speeches preserved in a newspaper, but the latter might keep his memory alive for a year or two, but not much longer.